Hey, everybody. We are still talking about equal protection, and today we're talking about sex discrimination and therefore intermediate scrutiny. One disclaimer about the language today: transgender rights have not fully made their way into the Supreme Court case law. And therefore, for today, for our purposes, we're going to imagine a binary world. People are male or people are female. And that's the way we have to continue because, again, that's the language that the Supreme Court has used, and we need to learn and talk about these cases. So let's discuss our path to intermediate scrutiny, which is obviously the thing that's missing on this slide. We know that if you have a suspect classification, you use strict scrutiny, other classifications, rational basis. But what about quasi-suspect classifications? We know that we use intermediate scrutiny for those. Now, before the 1970s, the law looked like this, what you see on the screen. The US Supreme Court's approach to equal protection had just these two levels. And under the California Constitution, this is still how it works. When questions arise about sex discrimination under state law in California, the California Supreme Court has said that sex-based classifications get the same sort of strict scrutiny that the state constitution uses for racial classifications. So again, in California, it's strict or it's rational basis. Under the US Constitution, it's really just recently that we have that middle level. So let's quickly review how we got there. Let's do a little tour. I didn't ask you to read all of these cases, but I want to give you a little bit of background as we move into the doctrine. The Hoyt case. This is a famous 1961 case, and it's an example of sex discrimination under the Equal Protection Clause that was decided under rational basis. Gwendolyn Hoyt, we see her up here on the screen, was a battered woman who was on trial for murdering her husband. Under Florida state statute, the state's jury selection system, and that's what's at issue for us, the jury selection system, that law that determines who do you get as your jurors, they sent summons to all eligible men, but women only got a jury summons if they affirmatively opted in. So meaning women were automatically exempted, they had to change and opt into the system. Of the 3,000 summoned jurors, only 35 were women, and Hoyt was tried and convicted by an all-male jury. Now, she challenged Florida's jury selection process, and she challenged it unsuccessfully, but we could have known that already, right? You probably already knew that because I said it was decided under rational basis. Now, the court says, yes, a woman is still regarded as the center of the home and family life, so it is rational to let her stay at home and not serve on juries. The court also said that having an all-male jury had no constitutional significance, and it is different from cases involving racial discrimination in the jury selection process. So that's where we were in 1961. We have the court explicitly saying, for this type of law, again, the jury selection process is what's at issue. We're going to use rational basis. And think about the assumptions built in here, the idea that women are still regarded as the center of home and family life. So it is rational to let them stay home. A note for everybody at home, this case was overruled by J.E.B. versus Alabama in 1994. You all know who this is, Justice Ruth Bader Ginsburg. Now, how did we move from this? How did we create that intermediate level of scrutiny? And the answer is it actually does have a lot to do with Justice Ginsburg, not just her, a lot of other people as well, but she really was at the forefront of getting sex discrimination recognized as a category that was entitled to heightened scrutiny. Again, it never goes all the way to strict scrutiny. but it is recognized as being entitled to heightened scrutiny and that middle category of intermediate scrutiny, largely because of her work. Again, not solely, but largely. And a lot of people draw parallels between Justice Ginsburg's work for gender equality and Justice Thurgood Marshall's work for racial equality. Are there differences? Of course, but in terms of being very strategic litigators who worked on their cause for years and years and then ultimately became members of the Supreme Court, there are certainly some parallels there. So how do we move away from analyzing gender discrimination under rational basis? In part, it's the women's movement starting in the 1960s, and it begins to change minds about what women are capable of doing and change minds about how harmful sex discrimination actually is. Ruth Bader Ginsburg was involved, as I mentioned, in a lot of the landmark cases in this area. And she basically had two goals in her litigation. Again, one was to get the courts to treat gender discrimination, sex discrimination as a suspect classification and therefore use heightened scrutiny. She didn't get that. She got the courts to treat gender sex discrimination as a quasi-suspect classification. And that's why we have intermediate scrutiny, not heightened scrutiny. She also, second, wanted to highlight the ways in which sex-based laws relied on socially created stereotypes rather than real differences between the sexes. And again, one of the key features in her strategy was to show that sex discrimination doesn't just harm women, but it also harms men as well. And that really informed which cases she decided to pick, which plaintiffs she decided to choose. Now, moving right along, the Frontiero case, really famous early 1970s case. Sharon Frontiero was a lieutenant in the US Air Force. Because she was female, she didn't get the same health insurance for her spouse as she would have gotten as if she was a male member of the military for a female spouse. So she has certain health insurance from the military, but because she's a woman, her spouse gets a lower level of health insurance coverage than if she was a man. The court says that this difference in treatment, it violates the Fifth Amendment due process clause. Again, reminder, why am I using the words due process? Because the Fifth Amendment due process clause incorporates the 14th Amendment Equal Protection Clause. So when we're talking about laws on the federal level, we talk about the Fifth Amendment Due Process Clause, which incorporates the 14th Amendment Equal Protection Clause. When we talk about laws on the state and local level, we just directly talk about the 14th Amendment. Now, the court, as we can see here, excuse me, is completely splintered as to the proper level of scrutiny. The court says, again, we're just not sure which, we know that this is improper, but we don't know which level of scrutiny to use. Brennan's plurality says that we should use strict scrutiny. Powell, in his concurrence, says no, explicitly says no strict scrutiny for sex, but he doesn't say what should be used. Stewart says this is invidious discrimination, and he doesn't specify a standard. Rehnquist says just use rational basis. We have no majority opinion, and so for a few years, we don't know. Basically, we don't know when it comes to a law or practice that leads to gender discrimination. And this, again, is disparate treatment. It's on the face of the health insurance policy. It's not disparate impact, it's disparate treatment. We don't know what to use. And it's not until a few years later in Craig versus Boren that we do figure out what's the level of scrutiny here. So this case involves an Oklahoma law that says 18 to 20-year-old males could not buy 3.2 beer. That is a type of low point beer This is the end of my knowledge base when it comes to low point beers, but females of the same age can. So let's just imagine any product. Men who are 18 to 20 cannot buy that product. Women who are 18 to 20 can buy that product. What does the court say? By a vote of 7-2, excuse me, the court says that gender should be subject to something that we now call intermediate scrutiny. It's higher than rational basis, it's lower than strict scrutiny. And as we're going to see in our cases today, it's not always exactly the same. Sometimes it looks a little stricter and sometimes it looks a little more deferential. Now, there are two basic prongs, as always. Prong number one for intermediate scrutiny, just the same for rational basis, just the same for strict scrutiny. Prong number one is, what is the government's ends or purpose? And here we see it on the screen, important. So it's not compelling, which is strict scrutiny, and it's not legitimate, which is rational basis. It's important. Now, prong number two, the means. They must be substantially related to achieving that goal. Now, again, it's not closely drawn or even narrowly tailored is really the language that we use more often. It's not narrowly tailored as it is for strict scrutiny, and it's not rationally related as it is for rational basis. It's substantially related. So again, for strict scrutiny, we need a compelling interest, we need narrow tailoring, the least discriminatory alternatives. For intermediate scrutiny, we need important government purpose, we need substantially related, and for rational basis, we need a legitimate government purpose and a rational relationship. So that's just a quick review of our three levels of scrutiny, and here they are. Use this slide when we're thinking about equal protection questions. This is our roadmap. So to the extent that we get a little bit in the weeds at times and you're wondering, where are we? Again, this is the roadmap. This is the guide for us. And I want to emphasize something that I've pointed out before, which is strict scrutiny and intermediate scrutiny are both forms of heightened scrutiny. And the difference between intermediate and rational should be much greater than the difference between strict and intermediate. And that's, again, because both strict and intermediate are some form of heightened. That means that the court is going to demand more of the government in order for the government action or practice to be constitutional. Now, what makes the classification suspect? This is just a quick reminder here. We've seen this slide before. We've talked about this, but to the extent that there is, for instance, a exam question and you feel like I'm pointing you towards asking, should this new group be treated as suspect or quasi-suspect? Again, these are the factors here that we consider. So I just want you to have this handy at this point in the lecture. And again, this is where we end up. So what falls within suspect classifications? As a reminder, race and national origin, classifications based on race, classifications based on national origin, quasi-suspect classifications, sex, classifications based on sex, classifications based on whether or not you were born to a married couple or an unmarried couple. We'll talk about that a little bit more. And other classifications, everything else, right? Everything else I'm not even going to list, but the common classifications that get rational basis deal with economic opportunities often. Now, some intermediate scrutiny cases look pretty strict. And some of them, as I mentioned, they look a little bit more deferential. What we need to look for is language that we're going to see in this case, a very famous gender discrimination case, Virginia Military Institute. And this case uses the language of exceedingly persuasive justification. You see in the language that the justices use that they're either trying to make intermediate scrutiny sound really, really similar to strict scrutiny. Again, exceedingly persuasive justification. You're trying to kind of push intermediate scrutiny up into strict scrutiny, or they kind of water it down in different ways. And we'll be able to compare at the end an opinion by Justice Ginsburg and then another by Justice Kennedy, the Wynne case. So just previewing that concept, VMI and Morales-Santana, both written by Justice Ginsburg, those look pretty strict. And then Wynne, written by Justice Kennedy, it looks a bit more deferential. All right, let's pick back up and keep moving with Virginia Military Institute. So the case is called U.S. versus Virginia because notice, and this might seem normal now, but the Justice Department is the one who sued to have VMI's all-male admissions policy declared invalid. This represents a huge change. To have the executive branch seeking to enforce sex equality against a state actor was not typical really up until very recently. And the case actually started under the George H.W. Bush administration. So please don't think of the case as necessarily a Democratic or Republican or left or right project. This just became the policy of the Justice Department moving forward. All right, so what does, excuse me, what does Virginia Military Institute have to offer? This is what they have to offer, a certain type of education, one that you are not accustomed to in law school. It's very different. Now, a summary of the case. Virginia Military Institute, which I have referred to as VMI, was Virginia's only all-male public undergraduate institution. Obviously, you know it's public, but I want to emphasize that because that's the reason that we're talking about this as a potential equal protection violation. We need a state actor, and we can have, quite obviously, private institutions decide to be single sex, and we don't therefore have an equal protection, an equal protection clause violation. So in response to the litigation in this case, Virginia says, no problem, we'll just create an all women's school. We'll create the Virginia Women's Institute for Leadership as a parallel program for women. But we know where this is going, right? We all know where this is going from Plessy versus Ferguson, which is the separate is not equal. And the court said VMI's male-only admissions policy was unconstitutional under the 14th Amendment Equal Protection Clause, and the creation of the Virginia Women's Institute for Leadership, VMIL, it's sometimes called VMIL, didn't solve the Equal Protection Clause issue. Again, because separate, it's not equal. And notice the language that I've already mentioned before. The key language, I think, from the case, the court says Virginia did not have a, quote, exceedingly persuasive justification for its male-only admissions policy. All right, let's do our usual analysis. Let's think of how to tackle this. We want to know, not just as constitutional scholars, but as people who are going to at some point take a constitutional law exam. So A1, what benefit is distributed unequally? Enrollment at VMI. Is that a fundamental right? No, it's not. And we're going to do a case soon called Rodriguez, and we'll see there that the ability to enroll in VMI and, in fact, the right to public education in general, not seen as a fundamental right. So this A1 points us to rational basis. A2, what's the classification here? Is the first thing we look at, is there disparate treatment? And the answer is yes. The admissions policy says male only. This isn't the firefighter example where it says only people who are 6 feet tall, and we have to think about disparate impact. This is disparate treatment. It's on its face. Only men can go to VMI. So what's the level of scrutiny? Now we know after Craig v. Bourne that it is going to be intermediate scrutiny. Why? I was pausing for a minute because it's a quasi-suspect classification and we're going to use intermediate scrutiny. Now, let's think about this. What are the government's interests here? So the first one, we see it on the screen here in this column. It's really the idea of a variety of educational models within the state system, including options that are single sex. Now, does the court consider this to be an important interest? So we're talking about this column, ensuring a diversity of educational approaches. And now we're talking about prong number one. Is there an important government interest? Why are we asking if it's important? Because we're talking about intermediate scrutiny, and that's prong one under intermediate scrutiny. And the answer is, check or X, and the court doesn't really directly answer it. The court basically says this isn't your real reason. And notice that that's the hallmark of heightened scrutiny, which is a court looking behind what the government says, kind of opening the hood and saying, really, is that really what you intended to do? And here the court says, no, we're looking for actual legislative motivation here, and that ensuring a diversity of educational approaches isn't it. So what about the second interest? Basically, avoid destroying or diluting VMI and their particular educational approach. The idea that, let's just say it, it's the idea that women would ruin the program. Does the court reject this? So again, we're talking about column number one. Now let's talk about prong number one. No, what the court says here is some women are capable of withstanding the program, and the state cannot have a, quote, total disregard of their individual merit. The state can't totally disregard these women and their individual merit. That doesn't precisely respond to the argument that women would ruin or dilute the program. But throughout the opinion, we see that the court obviously thinks that women would not, in fact, ruin the program. Now, let's talk about Justice Scalia here for a minute. Justice Scalia says allowing women into the institution will change it. Even if the majority seems to deny this, that women would change it, and presumably not for the better. So let's assume he's right. And presumably I'm saying that's Justice Scalia's view, not my own. Let's assume he's right. Should that change the result here? And the answer is maybe not. So again, what we're assuming is maybe women would significantly change and, let's say at the very least, dilute the program, that it would not be the same. And the answer is maybe that still doesn't indicate that the all-male admissions policy should be upheld. There's some people, for instance, who think that maybe public institutions, that there's no place for same sex, that they should all be co-ed, and we should just leave this to the private sector. The government options, the argument is, should always be more limited than the public sector in this case. And what we want under the Equal Protection Clause is individual opportunity, not necessarily group opportunity. So what we're worried about for the Equal Protection Clause is the woman who can be admitted into, Virginia Military Institute, that they have the opportunity to do so, even if it changes the experience for the other people there. So that's just a quick discussion of, well, what if Scalia is right? And in fact, the experience is different. And the answer is the all-male admissions policy still might fail under the Equal Protection Clause. Now, the next thing I want to talk about is stereotypes. And this is one of Justice Ginsburg's lifelong interests, is talking about gender stereotypes and how they in fact harm all of us. And this slide obviously, talks to us about the difference between ability and stereotypes. Now, in this case, the court is willing to assume that most of the people who will succeed at VMI will be men. The court is saying, maybe it looks like this. Again, maybe the vast majority of the people who can succeed at VMI will end up being male. But this high correlation, it's not enough of a substantial relationship. Now we're talking about prong 2. It's not enough of a substantial relationship to satisfy intermediate scrutiny. So think back here. What if the vast majority of the people who can be successful at VMI are male? That's not enough for a substantial relationship to an all-male admissions policy, to support an all-male admissions policy. What the court says here is that gender-neutral rules must be adopted to allow all qualified women, so this sliver, to enter. Even if there's only one, we need gender-neutral rules. And then we have this quote from JEB versus Alabama, which I referenced very briefly before, basically telling us what? If a law relies on sex stereotypes, on gender stereotypes, it doesn't matter whether or not there's some statistical support that can be conjured up for the generalizations. Okay, so let's put this in prong 2 language. Let's talk about whether or not there's a good fit, whether or not there are less discriminatory alternatives. So over and under inclusive, let's think about an admissions policy that says all men, no women. That has both problems being over inclusive and under inclusive, in the sense that it's under inclusive, it doesn't keep unqualified men out, and it's over inclusive, it keeps qualified women out. So that's not a situation that has a good fit. That's not a good level of tailoring. What about less discriminatory alternatives? Well, we could have an entrance exam, for instance, based on aptitude. That would be less discriminatory. Of course, the assumption there is that we could easily test for aptitude and we could do so in a way that doesn't have other problems. Let's think back to Washington versus Davis. But at least theoretically, there are less discriminatory alternatives. Now, I want to move on from talking about ability versus stereotypes to talk about this idea that we brought up before, separate but equal. So I mentioned this in the beginning. Virginia says, okay, well, our response to this suit will just to be, we're going to create an all-female institute and it will do almost the same thing. And so we do not have to let women into VMI. And we know that, and we know this from pre-Brown cases, right? We know that these programs are never equal. And we can see the differences here, differences in goals, differences in methods. But I want to have a thought experiment for a minute. Let's assume that they actually are equal. Again, we know from pre-Brown litigation that they never are, but let's just have a thought experiment. They are equal. Look at the language here that we see from Brown versus VMI. Brown tells us we conclude that in the field of public education, the doctrine of separate but equal has no place. So separate but equal when it comes to segregation along racial lines, it has no place. We talked about that in some depth when we discussed Brown. And then look at VMI. Single-sex education offers pedagogical benefits to at least some students, Virginia emphasizes, and that reality is uncontested in this litigation. So VMI tells us that there are some benefits to being separate. If those two institutions are truly equal, there are some benefits to being separate, but again, they're not equal. And what we see from the litigation and the case and the doctrine here is that it's a sex-based classification, it gets intermediate scrutiny, and it does not pass that scrutiny. what happens today. This is the more current view of VMI. There are both women and men, and famously Justice Ruth Bader Ginsburg actually spoke at one of the graduation ceremonies for VMI. Okay, that's our discussion of VMI. And now let's talk about, I'm going to call it the IAO case. This is a 1974 case, and this case talks about and touches on biological differences between men and women. Again, the same disclaimer that I used at the beginning of this lecture. We are discussing these cases in a binary world of there are men and there are women, as I explained, because the Supreme Court case law has not really tackled the issue of transgender rights, at least with respect to the Equal Protection Clause. And so in talking about these cases, we're going to live in the same binary world that they were in order to understand the cases and what's going on here. So the IAO case, California has a disability insurance program that covers absences from work on a basis of, quote, temporary disabilities. So you have something like a broken leg, it's longer than 8 days, it's shorter than 26 weeks. There is a disability insurance program. The benefits include paying a portion of your salary while you're away from work for health reasons, paying some medical bills. It's not clear from the opinion exactly which medical bills are covered, but paying some medical bills. And the battle in this case is over whether pregnancy should be considered a, quote, disability under the program, and therefore whether or not pregnancy should be covered. The portion of the case that makes its way up to the Supreme Court only deals with the exclusion of disability resulting from, quote, normal pregnancies. And in this case, we have a plaintiff here, Carolyn Iao, and she experiences a disability as a result of her pregnancy. She's ineligible for benefits from California's disability fund. We know that because we know that they carved pregnancy out, so it's not covered under the listed disabilities. And that's part of California's unemployment insurance code. Again, it lists a bunch of disabilities that are covered and pregnancy is excluded. She says that that exclusion violates her 14th Amendment Equal Protection Clause rights. And Justice Potter Stewart, writing for the majority, it's a 6-3 decision, says, no, it doesn't. Now, the court does not apply intermediate scrutiny here because they view this as a classification based on pregnancy, not on sex, in part. Also, notice it's 1974. And remember when we talked about the development of the doctrine and when we talked about when we started using intermediate scrutiny. So the court, again, does not use intermediate scrutiny for reasons that make sense, both based on what they view as the relevant classification, pregnancy, not sex, but also because of where we are in the development of the doctrine. It's 1974. So the court sides with California here. They say that California has an interest, and it's basically, excuse me, a financial interest in keeping this disability program solvent, meaning making sure it doesn't go bankrupt, so that at least some people are covered by it, and also keeping the contribution level for the program low. And what the court accepts from California is that if they included disabilities from normal pregnancies, that would financially stress the program essentially to the breaking point, that it either might become insolvent or that they would have to raise contributions or get more money from other places, like a state subsidy. And what the court says here is, look, to the state, you get to decide which disabilities to include because you don't need to attack the entire problem at once. And notice that sounds like language that says what? it says being under-inclusive is okay. So again, the Supreme Court is saying to California, you could decide just to cover some disabilities, not all, because you can tackle some of the problem at once. And again, that language should sound very familiar coming all the way back from Caroline Products, that being under-inclusive is okay if we're not using heightened scrutiny, and we're not using heightened scrutiny here. So let's move on to the Kickstarter for a minute. One more thing I actually want to mention on this slide is, and the dissent notes this, that there are no exclusively male disabilities that are excluded from the program, like disabilities related to, for instance, a prostate surgery or problems with one's prostate. And so the dissent says, like, you carved this up so that the one disability that's not covered is exclusive to women, but there are no disabilities that are excluded that are only male disabilities, that only men can experience. So let's move on to the Kickstarter here. Now, what right, A1, what right is burdened here? The right to disability payments. Is that a fundamental right? No. The government, as we've talked about, doesn't have to give those payments at all. And once they decide to give them, when they exclude or take away those payments, that's often where we have a procedural due process analysis, but that is separate from whether or not there's a fundamental right here. The ability to get those payments from the government, that is not a fundamental right. Okay, so A1 points us to rational basis. What about A2? Who's affected by the classification? This is where we have a fork in the road, right? On the one hand, is this a classification on the basis of pregnancy, or is this a classification on the basis of sex? Now, in at least one passage, footnote 20, the majority seems to think that this is not a sex classification, and instead says that the relevant classification is pregnancy status. Do we agree with that reasoning? Well, number one, again, we're still in our binary world. Number one, only women have the capacity to be pregnant. So only women would ever be burdened by this classification. We can make an argument that there are men that are indirectly burdened by this classification, for instance, because their wives don't get disability benefits, but we're focused on direct burdens right now. So having said that, when it comes to, again, only women, we're still in our binary world, have the capacity to be pregnant, it sounds like that is a really close proxy for this is a sex-based classification, but the court doesn't use that path. The court says no. What else? So number two, insurance is supposed to buy peace of mind, but only women have to fear that a foreseeable disability will go uncompensated. Number three, even beyond losing the payment for the disability, it makes women uniquely less able to participate in the workforce in the same way. So there are some good reasons here, I think, to say the relevant classification should be treated as a sex-based classification. Let's think about our disparate treatment versus disparate impact language for a minute. On the face of it, the disability fund and the California Code, they talk about pregnancy. So on the face, there is no disparate treatment on the basis of sex, but there is a disparate impact. And there's a huge disparate impact. And I think what we could say is, because there's such a strong correlation, the court could have decided to view this as a sex-based classification, but again, we know they did not decide to do that. Now, what does that mean? Well, it has a pretty huge impact for the case, right? If we decide that the relevant classification is based on sex, intermediate scrutiny, at least today. If it's pregnancy, then rational basis. As we know, if you use rational basis, then the program or action is likely to be upheld. If you use intermediate scrutiny, then much, much less likely. It's not like strict scrutiny where absolutely the thing will be struck down if you use a true strict scrutiny, but it's much harder to satisfy. All right, thinking about disparate impact for a moment as we compare this case to our prior cases, what I want you to see is that the disparate impact on women here is pretty complete. Again, we're talking about direct impact. We're not talking about the ripple effect that occurs in society when certain people are not able to get disability benefits. One other thing I want to point out. So again, when we're in our Kickstarter and we're talking about A2 and we're saying, what's the relevant classification here? Number one, we look on the face of the government action, sometimes on the face of the statute. In this case, the face of the statute discusses the difference between pregnant people and not pregnant people. And so disparate treatment is not on the basis of a suspect or quasi-suspect classification. Then we move on and we talk about disparate impact. In this case, we can see it very starkly. Yes, again, there absolutely is a disparate impact on women. So then the question becomes, should we treat the relevant classification as based on sex, at which point it would be a quasi-suspect classification and we should use intermediate scrutiny? And the answer is that we look for something really stark, like in Yik-Woo, and maybe this starts to look like a Yik-Woo situation. And what we look for is discriminatory purpose. We talked about this in class. We're looking to see if the government is acting with a discriminatory eye. And one thing I just want to emphasize here is that if we ever do find that the government has a discriminatory purpose, then scrutiny is really easy because every level of scrutiny fails. If the government acts with, and we've heard this language before, if the government acts with animus, that is not a legitimate purpose. That's not an important purpose. It's not a compelling purpose. Once we find discriminatory purpose, the government is out. It cannot act. The thing is unconstitutional. Now, for purposes of an exam, still move on to prong 2, which is tailoring. But know that, again, once we find discriminatory purpose, the thing will not survive. It will not be constitutional. Okay, so with that, let's move on and apply the scrutiny here. Again, we are talking about a disability insurance program, and we're talking about a program that covers some disabilities and not others. And in this case, we're carving out pregnancy as a disability. What's the government's interest here in excluding normal pregnancy from its health coverage? Well, the interest is, as we talked about, they want to have a solvent disability insurance program, and they want to keep contributions relatively low. So it's a monetary interest in many ways. Now, is solvency of the program a legitimate or important reason? And excuse me, the answer is it's certainly legitimate. It might not be important, but we're not using intermediate scrutiny. If we required California, excuse me, if we required California to include pregnancy in the plan, the price goes up and it'll be too expensive to fund via these relatively low employee contributions. So we might have to, for instance, have a state subsidy instead. Excuse me, rates might also go up. Other benefits might go down. The worst case scenario is that the program shuts down entirely. So what we have here is a legitimate government interest, maybe not an important government interest. Now let's consider prong 2. Let's consider tailoring. assuming, again, that the government interest is strong enough, we move on to part two. Is the law properly tailored for rational basis? Is it rationally related? And the answer is yes, very, very probably. Picking a single health problem, we're going to use the word problem broadly, like pregnancy, and excluding it from coverage serves the goal of cost saving. It serves the goal of making sure that the program is solvent and it's easy to administer. That's enough for rational basis. There's no obligation that it be the least discriminatory alternative. Now, what about for heightened scrutiny? Probably not enough. It's certainly, as we've talked about, not the least discriminatory alternative. We could achieve our financial goals in sex neutral ways. We could keep the contribution rate at 1%, but we could adjust other benefits. We could say other things aren't covered, or other things are covered to a lesser extent. We can also consider other factors when we're thinking about heightened scrutiny, such as the extent to which a law like this actually enforces stereotypes. And so what we can think about is whether or not a change in the disability program could actually create real changes in the workplace. And not for right now, but we can have a real discussion about whether changing the law can actually change what we think of as a quote unquote normal worker. Now, there was a certain period of time where women entered the workplace, for instance, in World War II, in a Rosie the Riveter type of situation where women have to enter the workplace because men are abroad, they're fighting the war, but then the women are expected to go back home and tend to the houses when the men come back. And we have to remember that context and that backdrop when we're thinking about these cases, and we're thinking about what the government expects a quote unquote normal worker to look like, and whether or not changes in the law can, again, change our perception of what a workplace should look like. Now, is this case still a good law? So again, we know that we use a lower standard of review, and we know that, sorry, I went ahead for a minute. We know we use a lower standard of review. We know that California's particular setup here is found to be constitutional. Is this still good law? Well, as a practical matter, Congress has made the question irrelevant because they've enacted the Pregnancy Discrimination Act. It amends Title VII of the Civil Rights Act to say that denying certain benefits related to pregnancy is considered to be a type of sex discrimination in employment. But what if the statute were repealed? What if the Pregnancy Discrimination Act were repealed? Then we would be faced with deciding whether or not this case is still good law. It hasn't been directly overruled, but I think it's ripe for overrule because it really should apply intermediate scrutiny as required, again, by Craig versus Boren. That was that case dealing with the beer and that men from 18 to 20 couldn't buy a certain type of low point beer. At the very least, it's really ripe for reexamination. And so that's where I want to leave it with this particular case. All right, we're going to finish our discussion of intermediate scrutiny by talking about this pair of cases, Wynn and Morales-Santana. Now, they both involve different aspects of the same federal statute. One thing to note at the outset, if we're thinking about our Kickstarter under A1, there is no fundamental right to be given US citizenship if you're born outside of the US. So A1 would lead us to a rational basis discussion. But why are we having this discussion under our intermediate scrutiny day? Because A2 does bring us to intermediate scrutiny when we're dealing with sex-based classifications. And we are, in some cases here, dealing with sex-based classifications. You can see on the screen here, there are different rules that relate to whether or not somebody's father is a citizen or the mother is a citizen. So we're talking about people who are born outside of the US, and there are different rules for them obtaining citizenship depending on whether or not the citizen parent is the mother or the father. So let's focus first on the Wynn case. And we can see here the timeline in the Wynn case. I'm going to give a summary overview. We can see here Wynn is born to unmarried parents abroad, and the citizen parent is his father, and the non-citizen parent is his mother. The federal statute at issue in this case, 18 USC 1409A, you do not need to memorize this, again, imposes different requirements for how a child gets citizenship depending on whether or not, as we said before, the citizen parent is the mother or the father. Now, Justice Kennedy writes the majority opinion for the court here. It's a 5-4 decision. And what he says is the statute is constitutional under the Fifth Amendment due process clause. Again, it's a federal statute. So we're talking about the Fifth Amendment due process clause, which incorporates the 14th Amendment Equal Protection Clause. And what Kennedy says is this passes constitutional muster, even though we do have this different treatment, even though we have these different requirements on children based on whether the citizen parent is the mother or the father. Now, here's the defendant in this case, and he will be deported to Vietnam if he's not a US citizen, but he can stay in the US if he in fact does have citizenship. Under the statute here, we're repeating ourselves a little bit. I think it's clear from the case, but under the statute here, if he would be a US citizen if his father did the necessary paperwork before his 18th birthday, but he never did that paperwork. And so what we find is that, in fact, he is deportable. If his citizen parent, instead of being his father, had been his mother, then there's no paperwork requirement, and he would be a citizen, and therefore he would not be deportable. So again, because the citizen parent is the father, there's a paperwork requirement, it's not satisfied, and therefore he's deportable. If the citizen parent is the mother, there's no paperwork requirement, he's a citizen, he's not deportable. So let's talk about the government interests at issue in this case. Generally speaking, the goal of the law is to give citizenship to the children of US citizens. Again, generally speaking, but to deny it to quote unquote imposters. So specifically, the law is supposed to provide proof of two things. One, that the alleged US citizen parent is really the parent of the child at issue here. And the court says this is harder to prove for fathers than it is for mothers. Again, proving that link between parent or alleged parent and child. And two, the other government interest here, as we see on the screen, this second column, ensuring that the child has an opportunity to develop genuine family ties to the US parent. Now, let's take each of these interests in turn. For number one, are these important interests? Again, if we're doing intermediate scrutiny, because this is on its face a sex-based classification, if we're doing intermediate scrutiny, then we're asking if the government interest is important. And for both the majority and the dissent, number one is important, making sure that we don't have an imposter situation, making sure that the alleged citizen parent really is the parent in this case. Both the majority and the dissent say, yes, that is important. Now, for number two, ensuring that the child has an opportunity to develop genuine family ties to the US citizen parent. For the majority, that's important, but not for the dissent here. The dissent says this isn't an important government interest if you're going to extend it to the mere opportunity to have family ties. And The other thing the dissent says here is, even if in general this was important, why deem it only important for children and their fathers? And that really links to a tailoring question. So what do we see here in this case? As is typical, the majority that says we're going to uphold the statute accepts both of these interests. The dissent accepts one, but not the other. And so that really brings us to prong two, to talking about tailoring. And is the law in this case, is it substantially related? That's a level of tailoring, again, that we need for intermediate scrutiny. Is it substantially related to the government's goal here? And again, the goal being that the alleged US citizen parent really is the parent of the child that is trying to get citizenship. And the answer is maybe, but there are sex neutral alternatives. For instance, maybe both the mother and the father must have a DNA test. What if the statute said mothers can sign an affidavit of live birth, but fathers get a DNA test? That would probably, underline probably, that would probably be okay, because intermediate scrutiny does not demand perfection. And there doesn't seem to be a huge harm in this. But again, the majority says, you know what, this is enough. And so for the majority, we move on, and for the dissent as well, we move on to prong two. Are the means chosen by the law in this case substantially related to the goal of ensuring that the child has a real family relationship with the US citizen parent? The majority says, yes, this is enough. The dissent says, no, the mother's mere presence at birth gives no certain opportunity for a lasting relationship. These built-in stereotypes should no longer stand. And the dissent accuses the majority of not doing true intermediate scrutiny, meaning being too deferential and basically lapsing into rational basis. Now, are there potentially other factors going into the majority's decision here? Maybe. Let's think about some other things that are going on in this case. One, extra deference to Congress in the area of immigration. When it comes to institutional competence, typically the courts are going to say Congress has a better sense of what it should do when it comes to immigration, and we should really be a little more hands-off. Two, maybe what else is going on here? Very little sympathy for the deportee in this case. He's a convicted child molester. He's not a particularly sympathetic plaintiff. And three, maybe wanting to avoid a flood of unexpected, quote, unexpected citizens conceived to the typical classic example would be the soldier father. So do we know for sure? No, but I tend to think that what's happening here, at least in part, is the court saying Congress has a lot of institutional competence when it comes to immigration. Now, I want to talk about the next case, the Morales-Santana case. Again, quick summary, we're talking about a different part of the same federal law. And that part of the law that was in place when Morales-Santana was born says a child born outside of the US to an unmarried couple, to an unwed citizen father and non-citizen mother can only get citizenship at birth if the father was present in the US for a total of a decade, 10 years before the child's birth. At least 5 of those 10 have to be spent in the US after the father was 14 years old. But again, different treatment if the citizen parent is the mother. If the mother is the citizen parent, then the law only required physical presence in the US for a year before the child's birth. In this case, in the Morales-Santana case, the father cannot satisfy the physical presence requirements. And in this case, the court finds, unlike in the Wen case, that there is a violation of the Fifth Amendment due process clause. The court applies a real heightened review here. It's true intermediate scrutiny and says that the law fails. The goal basically being here, ensuring a connection between the foreign-born child and the US. We'll talk about that in more detail in a minute. And the means, the majority says it fails. The law is based on the assumption, again, notice all of this discussing stereotypes. The law is based on the assumption that the unwed mother was the sole or primary parent. All right, so let's talk a little bit more about some details here. Morales-Santana was placed in a removal proceeding after he's convicted of felonies, which are not really at issue or important for us. He argued that the denial of his citizenship, in this case, basically derivative citizenship from his father, violated the Fifth Amendment due process clause. He said, even though his father does not, there's no question about this, even though his father does not satisfy the requirements here, the physical presence requirements for unwed fathers, he did meet the less stringent requirements for unwed citizen mothers. Okay, what else is going on here? Here, the necessary proof of parentage has to happen before the child turns 18. But the thing that prevents Luis from being a US citizen is that before his birth, his father does not live in the country, in the US, for 5 years after his father is 14. In fact, he left Puerto Rico for the Dominican Republic 20 days too early. So this is a good case in a lot of ways, in the sense that it's such a close call. They miss it by less than 3 weeks. And of course, if Jose, the citizen father, had been a mother and the less strict rules apply, then he would only need to establish that 1 year of residency, meaning the standards for getting derivative citizenship from the citizen parent would be much lower. That's really what we're looking at. We don't need to remember the specifics of the statute. What we need to remember is harder treatment if your citizen parent is the father, and more easier treatment to get citizenship if your citizen parent is the mother. Now, I mentioned one government interest briefly. There are actually two here, and let's talk about them each in turn as we're finishing up our discussion. One, ensuring that the child's citizen parent has a strong connection to the US. And two, preventing statelessness. As the court says, preventing statelessness means a child's possession of no citizenship at all. So let's talk about the first government interest first. We can assume that these means are important. Again, important is what we need for intermediate scrutiny. But when we come to means, when we come to prong 2 here, the argument buys into a gender role assumption that the father doesn't see the child as much, so we demand more proof that the father is a genuine US citizen. What about statelessness? Again, we can assume an important end, but there's no real evidence that it is the true reason. And then what about prong 2, the means? It probably doesn't reduce statelessness at all. The sex classification as written avoids a statelessness problem for children of US citizen mothers, but not for children of US citizen fathers. So it's really under-inclusive. Now, what's the role of the history that Justice Ginsburg talks about in Part 3A of the opinion? It shows, again, and this is the focus of much of her work as an advocate and then as a Supreme Court justice, it shows that gender roles and sex stereotypes that are built into the law. It assumes a couple of things, right? One, within marriages, the husband dominates the wife, and two, outside of marriage, only the mother will really have a genuine caretaker role. let's think about the two cases that I don't want to get to remedies yet. Let's talk about the two cases that we just did. Are they consistent with each other? We have Wen, we have Morales-Santana. Big picture, I think what we see, as I said to you in the very beginning of this video, is that we see very different approaches to intermediate scrutiny. What about on the level of doctrine? Well, on the level of doctrine, they can coexist because they offer different, they involve different portions of the statute and offer us very different facts here. Now, as explained in part 3B of the opinion, Wen said that men and women are not similarly situated with regard to demonstrating a connection between parent and child. But Morales-Santana says that they are similarly situated when it comes to demonstrating a connection between citizen and country. So for Justice Kennedy, who wrote the Wen opinion, but joined Morales-Santana, that probably is the relevant difference here. Again, for Wen, that part of the opinion says that men and women are not similarly situated when we're talking about showing a connection between parent and child. But then Morales-Santana tells us that they are similarly situated when the connection is between citizen and country. And so we're trying to figure out, how can Justice Kennedy write the opinion in Wen and join Morales-Santana, because that difference was probably key for him. That difference was relevant for him. Now, does Morales-Santana, this second case that we've been talking about, does it represent a change to the intermediate scrutiny standard? And I think the answer is probably not. But as with VMI, there are a number of rhetorical choices that are made by Justice Ginsburg that seek to, as we talked about, push intermediate scrutiny to a stricter place. Just as Wen made some rhetorical choices to push intermediate scrutiny down to a more deferential place. Again, coming back to what we talked about in the very beginning. Let's talk about the language that Ginsburg uses. The opinion doesn't, the Morales-Santana opinion nowhere uses the term intermediate scrutiny. Instead, it uses heightened scrutiny, again, trying to link the level of scrutiny we use for sex-based classifications more strongly to strict scrutiny. It occasionally reiterates that exceedingly persuasive justification language that we saw in VMI. And it includes sentences like this one. Lump characterizations of that kind, however, no longer pass equal protection inspection. So in so many ways, what we're seeing here is that Justice Ginsburg is trying to make that intermediate scrutiny as close to strict scrutiny as possible. Now, just a quick word on remedies here. So the existing law that we've been talking about makes it easier for citizen mothers, for women to transmit citizenship to a child. And we see this as an equal protection violation. So what do? Well, we can either make the law easier for men, or we can make it harder for women. Like, in order to make things equal, it's going to be either harder or easier. Now, what's the general rule that we follow in these situations? The black letter law that's described in the opinion, part 4, says that we should only be guided by what Congress would have wanted, or in the case of states, what the state legislature would have wanted. Now, is there a remedy here in Morales-Santana? Is there a text clue to what the legislature would have wanted? Well, there's a preference for striking exceptions and leaving rules. And in this particular case, the preference for unmarried women is viewed as an exception because Congress said, notwithstanding the general rule, do it this way for mothers. Now, conceivably, it could have been written the other way around, but it wasn't. And there's also significant guidance here from the consequences. Equalizing unmarried men up to the level of unmarried women would have kind of a strange result of treating unmarried couples better than married couples. I say strange result because that's just typically not how legislation wants to treat those two different couples. Here, the court says, let Congress do it. And that's where I want to leave it. I don't want to talk about parish right now. So that's where I want to leave it with this particular video.